Welcome to Unwritten Law. Mark Chenoweth and I are joined today by Casey Norman to discuss the case of base access versus the National Park Service. We have just returned from Houston, where Casey argued against the motion to dismiss by the National Park Service of our client's complaint that they have never been allowed to base jump from any of the national parks but one day a year. So, Casey, welcome to the program.
Thank you for having me on.
And why don't you tell our listeners about, and maybe our viewers too, about what's this case about? Why are we suing? And what is base jumping?
Sure. So we are all elite base jumper professionals here at NCLA. But aside from that, we are also
Yes,
into...
I've seen the photographic evidence.
Yes, I've been doing a lot these days. But we're also very interested in the constitutional aspects of this case, namely the question of whether an executive agency can write criminal laws that will put people in prison, give them permanent federal criminal records, things of that nature. And what the base jumpers have been facing in literally every single national park across the country for almost 50 years now are criminal penalties if they simply base jump in the parks. So we're bringing a non-delegation challenge to the statute that delegates that criminal lawmaking authority to the National Park Service, who has been prosecuting these base jumpers.
And what is base jumping?
Oh, yes. So if you think of skydiving, it's similar to that, but instead of leaping out of an airplane, you're leaping from a fixed object, like in the national parks, for instance, cliff sides, mountains, and you use sometimes a special parachute that's called a wingsuit, and it kind of allows you to horizontally glide for a long period of time before you release the parachute and land.
Like a flying squirrel.
Exactly.
Okay. So
A human flying squirrel.
Yeah.
And someone did that
Watch
right
me
here.
pull a rabbit out of this hat.
Someone did that right here in Arlington, Virginia, in the building next to ours.
Oh, yeah.
Really?
But that's definitely not permitted.
No, it was not permitted. But I didn't know that. How long ago?
Oh, last year, a year before?
Oh, wow.
Very recently. Yeah.
Oh, wow.
Yeah, there was
I heard.
there were criminal penalties attached to that. I
Yeah,
believe.
but I should specify, though, it's not the base jumping that's the criminal act. In most areas, base jumping is legal, but the issue is if you trespass, you break into an apartment building and leap off the roof, that's generally
And
not
that- yeah,
permitted.
And that was the case here. There was a trespassing charge.
Right.
That's right. Which maybe that wasn't criminal. I can't remember. But anyway.
The way I've always looked at it is that some places have removed the criminal penalties for suicide. So you can jump without a parachute, but jumping with a parachute, and then you're in
Criminal.
trouble. If you
Yeah.
try
Then you
to
need a
live.
permit.
Yeah, exactly. So in any event, we digress from the constitutional issues, which we will now come back to. But there's non-delegation, but there's also tell the audience about what the regulation actually says that they're supposedly have violated.
Yeah, so that brings us to our second challenge, which is vagueness under the Fifth Amendment due process challenge. We are saying basically that the regulation absolutely does not apply to base jumping, nor does it apply to any recreation at all. What the regulation actually says is that aerial deliveries are deliveries, like cargo deliveries down to the ground are not permitted unless you have a permit to do so in national parks. And if you look at when that regulation was issued, it was the 1950s, which is 20 years before base jumping existed. So this regulation clearly does not apply to base jumping.
As a sport.
Yeah, as a sport. It had never, I think that it was coined first in 1978. And as a sport, it just didn't exist, when this regulation was issued. And if you look at the history of this regulation, they're talking about cargo, dropping from airplanes and car transportation at the grounds, collecting it, nothing to do with base jumping.
And what was happening, I think, is pretty clear is that some of the national parks, just like you have, I know the Adirondacks where I go frequently, they have a park, but if you had previously had a cabin there or land there, that's not part of the park. But getting to it is the problem. So you either have to be able to go overland or somehow get there. And what people were doing was supplying their cabins by flying over and dropping stuff into the park.
Berlin airlift style.
Yeah, exactly. Berlin airlift style. So that's what delivery means. But here, people will take their RVs or their trucks or whatever into the park with their equipment. They've delivered themselves into the park already.
And they've paid for park access or whatever.
Right.
They're not trespassing.
But when they go to this spot and jump off, they're then supposedly delivering themselves again.
Well, the National Park Service would argue it's not aerial if you're driving yourself into the park. But still, I mean, if you move your body from one point in a park to another, is that delivering anything? I mean, you wouldn't say when you walk, or as you pointed out, there one example is if you jumped from a tree branch or a boulder, are you aerial delivering yourself into the park from one spot to another? It doesn't make sense.
Yeah, and
they haven't prohibited that.
And as Casey said in oral argument, if you hop around the park, are you depending on how high are you delivering yourself? But
Right.
let's get to that. So we had this case is filed in Houston. And we may get to why, because the judge asked. So why don't you tell us who were we before and what was going on? What was the motion about?
So we were before Judge Eskridge. This is the Southern District of Texas in Houston, as you mentioned. And the DOJ, the National Park Service, are challenging us on the basis of standing and then also the merits of our non-delegation arguments and our vagueness argument. So those are kind of the three facets that we focused on Monday.
They're not challenging venue.
They are, but their challenge is almost non-existent. They say basically there is no venue because there's no standing.
Okay.
So particularly the Houston plaintiff supposedly doesn't have standing, and if he doesn't, there's no venue. But I will, Casey, you were asked, the judge, Eskridge, obviously has been to a lot of parks. I mean, he was familiar with what Big Ben looked like and all these places, and he'd seen the movie Free Solo, obviously, because from his comments. I mean, it's not obvious everyone's seen it, but it was obvious from his comments. But he asked the question, why did you file in maybe the flattest part of the world for this base jumping? And Casey responded because the Ninth Circuit has precedent on this already, and the Eighth Circuit has precedent on this, but the Fifth Circuit doesn't have any. 10th, correct, Utah. He was interested in Utah. He seemed to know all the Utah parks.
Good.
So in any event, but so he was satisfied with that. He said, "Oh, no wonder." But it is true. Houston is flat.
I thought you were going to say because we didn't have a Kansas plaintiff. So
that would be good. So what were the non-delegation arguments of the government, and how did you respond?
So non-delegation is a tricky one because the Supreme Court has not found that any statute in the last almost 100 years, since 1935, until Bureaucracy actually, unconstitutionally delegated.
And that was the Fifth Circuit. The Supreme Court didn't reach it.
Exactly. It was on different grounds that they upheld the ruling. But the Fifth Circuit is on our side on that at least. So basically almost 100 years since the court has found any statute unconstitutionally to have delegated, lawmaking authority to an agency. But our case is interesting because it's not only a delegation of just general kind of lawmaking authority, there's also the criminal element. And there is a lot of case law in the Supreme Court and the Fifth Circuit that leaves expressly open the question of whether the intelligible principle test, which is just generally applied, it's basically a very low bar to meet for the government.
And what is the intelligible principle test?
In essence, it looks at a statute that's delegating lawmaking authority and says, is there any form of intelligible principle in this statute that kind of guides the agency's discretion in exercising lawmaking power? And in practice, this has meant, almost nothing. It has not stood as much of a barrier to agencies, exercising lawmaking power. But in the criminal context, there's a different question. You're talking about people's liberty, individual American citizens' liberty, potentially facing prison time. And the court has said, this is an open question whether or not this intelligible principle test we've formed is appropriate in the criminal context, because there's a lot at stake there that isn't in a normal civil case.
And what was our response in this particular case as to why there is indeed a non-delegation problem?
Well, if you look at the statute, so I did a lot of deep digging into the various cases where the court has found that there is an intelligible principle. And if you look at the Organic Act, which is what's relevant in our case, the act that delegates criminal lawmaking authority to the National Park Service, it is very, very bare bones. What it says essentially is whatever the Secretary of the Department of Interior, and he delegated to NPS, this lawmaking authority, whatever he deems to be necessary or proper for the use and management of the parks is fine. And go off and write criminal laws for whatever necessary or proper purpose you find. And if there's what the government argues are two goals that guide or confine his discretion in writing criminal law. And the two goals are to conserve the parks and to provide for the public's enjoyment of the parks. And somehow this is supposed to limit his ability to criminally, deem what conduct is going to land you in prison or not.
He also said something else that I don't remember reading from the briefs. He said, and plus, it's only in the national parks. It's not for America itself, so it's very limited.
85 million acres.
Right, I know, exactly. But I did think that was the old college try right there.
Yeah, although I think there's a different rule for BLM. Maybe he was trying to
Exactly.
That
is exactly right.
Yeah.
So
Bureau of Land Management, for those who don't know.
So there's that. There's also this idea of permitting. I think that for our audience, I think it impressed the judge. I don't think he knew this, so it's probably important to our audience too. What type of things are allowed in the parks without a permit right now?
Right.
And then some things that might be similar to base jumping that you can do with a permit.
Yeah, so this is a kind of a bizarre argument the DOJ seemed to be making throughout the argument on Monday. They kept implying that basically everything you do in a national park has to be regulated and likely requires a permit from the National Park Service, which is not the case. Obviously, you can go hiking. You can, and one of the examples that I raised was you can rock climb. I mean, it's including free soloing, which basically means that you have no harness, no restraint. You're just climbing up a vertical cliff with no protection at all, except for a parachute, which you're wearing in case you are about to plummet to your death. Which, again, that's almost exactly like base jumping, except you're wearing a parachute in case you make a mistake and are going to die. Whereas base jumpers will, peacefully hike up on the path that other hikers take and then jump down in a controlled manner. But somehow that act is criminal and prohibited, and this other act doesn't even require a permit, let alone, being a criminal act.
That's true. And so basically, if you're a bad free soloist, you can base jump all you want.
Yep. Exactly.
So, in any event.
It's a new style of base jumping.
Exactly. I slipped again. And so then the other one was hang gliding.
Yeah. So technically, the National Park Service says hang gliding falls under the same regulation of aerial delivery as base jumping, but the difference is that the National Park Service just routinely grants them permits whenever they ask. As far as we can tell, no hang glider in 50 years has ever been, charged with a violation of the rule because they're just given permits all the time. And hang gliding is like base jumping. You leap off of a cliff and fly around in the sky for a while, except instead of just a light parachute, you have like this 80-pound massive wing above you that you're dangling off of.
Right. And there's aluminum in it and stuff like that.
It can frighten the wildlife, I would think.
So actually,
it seems more like aerial delivery than
than
base jumping does.
Sure. And I think the judge didn't know that at the time. He was like, really? You can climb? And the government's argument was that, well, if you stay overnight on a ledge, you need a permit. So
I don't even know if that's true, actually.
But
I looked it up.
So in any event, so there are many things. I think that's arbitrary and capricious wasn't in here, but I think the idea that all these people can climb up all these mountains, up these cliff sides. You run into Robert Alt on your way up, I guess. He's our friend at Buckeye who climbs mountains. But anyway,
without a parachute.
Yeah. And that's okay, and that doesn't ruin anyone's enjoyment. But if you parachute down, it does. So the other thing that I found interesting is that there is one place you can base jump once a year. Tell us about that.
Yeah, so the one exception is in West Virginia. They have a national holiday called Bridge Day. And the big kind of event of the Bridge Day is base jumping. And it's a particular bridge in West Virginia where I think it's hundreds, if not thousands, of base jumpers have been safely jumping, as far as I can tell, without incident, no deaths for decades.
Yeah, it's the New River Gorge, I think, but
exactly.
It's on the back of the West Virginia quarter. If you're a quarter enthusiast or a coin enthusiast like I am, the back of the West Virginia quarter has that.
I didn't know that.
I think it's in the National Park Collection, if I'm not mistaken.
But the government kind of, the DOJ tried to portray it as, we grant permits. Look, it's this, we do that in West Virginia all the time. But I mean, I think one, we should emphasize it's once a year in one location. And two, the National Park Service didn't really have a choice in the matter because West Virginia controls and owns the bridge, and they love this holiday, and they really wanted base jumping to exist there. And the only way that they would allow the National Park Service to create kind of a national park,
take over the area,
in the area below, not just the river, but the whole area, is for them to agree to waive the permit requirement for that day. So it's not really as though National Park Service conducted any analysis and is giving out permits out of the goodness of their heart.
No, but it does show that it can be done in a national park without incident. And
Right.
it's not the kind of thing that needs to be criminalized for
Exactly.
crying out loud.
Well, also, the other thing is it doesn't, as far as conserving the park, one of the things Casey pointed out was that they don't know whether it's going to hurt the park because they won't do studies. It's a big catch-22 in that they say that you can't get a permit until they do a study, and they won't do a study. I mean, that's what's going on here, and they
just don't want to deal with it,
right.
is what it sounds like.
I guess so, and I'm not sure why, because the hang glider, I can't imagine the hang gliders have a bigger lobby than the base jumpers. I mean, I don't know how many people there are in these various groups, but it does strike me.
We allege in the complaint that historically at least, it seems as though the park rangers participate in hang gliding, so they favor that sport, and I think that might be part of the reason. There's just this long-standing feud, between the base jumpers and the hang gliders and the park rangers and the rule breakers, and they haven't gotten over that bitterness in almost half a century.
Well, who knew? So is there anything else from the
Hatfields and
argument
McCoys.
that people should know or that you found interesting?
Yeah, I think I found interesting that at the end, the judge reprimanded the DOJ a bit, and he said, I think you better go back to your client and, have them reconsider their criminal regulations because they are not reflective of modern interests. And I mean, I don't know if he was giving away, his full. I think he's probably got a lot of thinking to do, but I found that promising, and I think he's right.
Well, you know what that reminded me of when he did it? He did say, look, can't you look at this? But it reminded me a little bit of the First Circuit telling Congress that they better do something about the mackerel observers in the Gaethel case. And since then, Congress has done something about it because they didn't want the court doing anything, I guess, in that area. But it was true that the idea that they just no park ever did a study, because that's the other thing that came out that I didn't know. It's not, the head of the Parks Department does this. Each park has a head, and the head of that park is the one who can do it for that park. And
they have permitting authority.
Right. And as the judge pointed out, no one wants to base jump in the Everglades, right?
Right.
You can't find a high spot, and if you can, you land in alligators, right? So that's right out, I think.
But they're trying. I mean, we list in the complaint, I think it's like 12 to 13 different parks, everywhere basically where you could base jump. They've applied, they've reached out, they've said, hey, here's a way you could regulate us because we want to do it safely and do it in a way that doesn't impact the environment. And they either just get completely ignored or just, no, we can't give you a permit until we analyze base jumping, and we will never analyze base jumping, so no permits for you. And that's how it's been. And the court also ordered an informational brief for the government of how you get a permit and how you move to change the permitting system if you want. So we will get a brief from the government, and either we'll agree with it or we'll respond. And so that was interesting as well. I assume he wants to know how futile it is, I think. But yeah.
I can't read his mind, but it was interesting that was another thing he wanted to know.
Probably for standing purposes, because a big part of the argument was spent on the futility of asking for a permit, because some of our plaintiffs, including the guy who lives in Texas, they haven't requested a permit because literally no individual has been granted one for, again, almost
years.
Half a century.
And Base Access has been asking and asking and asking. He belongs to Base Access.
Right,
so.
right.
Well, thank you very much for coming on the program and describing your argument. I'm sure when we get an opinion, we will inform our audience. And we will be back with more Unwritten Law in a moment.
As we like to say here at NCLA, let judges judge, let legislators legislate, and stop bureaucrats from doing either.